Good afternoon, everyone. I'd like to welcome you to the Cook County Board of Commissioners special meeting today, Tuesday, August 6th at 4 p.m. And today our purpose is to have an overview of proposed ordinance related to cannabis. And before we get that overview, I'd like to just provide a little background information. The purpose of the meeting is for people who are either here in person or are watching us via live stream to gain some knowledge and insight about the work of our Cannabis Committee, followed by a chance to learn more about the proposed ordinance, and most importantly, to provide feedback and input. And I'll be taking notes over the next hour or so as we meet in order to collect that feedback and input as well. In order to enhance participation in this process, we have another town hall meeting coming up next Monday, August 12th at the ACA, the Arrowhead Center for the Arts, and that'll be at 4:30 p.m. We also have an opportunity for people to leave feedback in written comment online, and the county website on its main page has a button you can just press and it'll take you right to the place where you need to go to leave those written comments. And then there is also a voicemail set up so you can leave comments if you don't have a computer and can just leave those from your phone. To give us some background about how we arrived here today, how we got here, most of us in this room know that marijuana, cannabis, has been illegal in Minnesota for a long, long time and nationwide. But back in 2015, medical marijuana became legally available in Minnesota for the treatment of 9 different medical conditions. It is still considered to this day to be one of the most restrictive medical marijuana bills in the country. Then 2 years ago, food and beverages containing THC became legal in Minnesota, and THC is the chemical derived from hemp, and packages were limited to THC content of 50 milligrams and also in a 5 milligram per serving. These are products that we have in 13 different stores throughout Cook County. Gummies and THC beverages are the most common, and you can purchase them at all kinds of convenience stores throughout the county. Cannabis became legal in Minnesota a year ago on August 1st of 2023 and legalized for the use, possession, and cultivation, with some laws taking effect then, and then the Office of Cannabis Management, which we'll refer to many times today, OCM, is still working on some changes. Minnesota law permits adults who are 21 and older to purchase and possess up to 2 pounds of marijuana flower, 8 grams of concentrate, and 800 milligrams of infused edibles in a private residence. Growing at home is permitted as long as the plants cannot be seen from the outside. They have to be out of view and locked. And an individual can cultivate up to 8 plants, with 4 of them being mature, which means they are flowering at the time. The bill that passed the Minnesota legislature also removes all penalties for cannabis possession and results in the expungement of all previous criminal convictions for first-time and subsequent cannabis possession offenses. Since the state of Minnesota will begin awarding general licenses for the sale of cannabis in January, and later this month will begin with the social equity applicants, some guardrails might be appropriate to have in place in the very near future. Sheriff Eliason and Attorney Hicken requested earlier this year that a 2-year committee be established to discuss and create a proposed ordinance for the county to regulate cannabis business and also underage usage. The sheriff and our county attorney serve as co-chairs of that committee, and there are representatives from PHHS, Public Health and Human Services, our school district, ISD 166, the City of Grand Marais, the Cook County Chamber of Commerce, the County Board, General Citizens, and the Grand Portage Band. And with that background information, I will turn it over to Attorney Hicken to talk a little bit about the proposed ordinance.
Thank you, Madam Chair. I do have a PowerPoint presentation which talks about what the current cannabis laws are, because those obviously impact how we may wish to regulate cannabis here in Cook County. The local controls that are allowed by the state law, And then within that context, the cannabis ordinance, or number 66. I see that we don't have any members of the public other than a couple of members of the committee who I do want to recognize. The ordinance comes to you because of discussions had at the committee level. The county established the Cook County Cannabis Regulation Committee back in January. We first met in May. And today we have Chris Homiak here and also Mike Roth from the city, who've both been active participants. So I want to thank them for their presence. And then we also have Rocio here from Public Health. I think she's kind of a surrogate right now for Grace Grenager, who is on our committee also. But my question for you, Madam Chair, is do you want me to go through the whole presentation again like we did at 1 o'clock? If we don't have members of the public here. I understand that we might be streaming it, so.
That's correct. I think because we're streaming it, we should probably do that version.
Okay.
It's a little bit of.
The 1 o'clock covers it and say it was all given at 1 o'clock?
We can also put it on the website, which I think was a good suggestion.
Okay.
It's up to you. I'm happy to do it again.
Let's do an abbreviated version. I know
Okay.
that last night was a little bit longer, and I think an abbreviated version would be good.
Okay, great. I'm going to try my best to make it abbreviated. Okay, so we talked about the Cannabis Regulation Committee already and the committee process. We've met 3 times. There was not, I can't say that we had a consensus around every single topic that appears in the ordinance. We did discuss most of the topics that appear in the ordinance, and there wasn't any strong objection that I recall to anything that we have in here. The piece that we didn't talk about in detail was the part of the ordinance that relates to underage prohibition of, the penalties created for the underage possession, use, or transport of cannabis. That's something that I am recommending as county attorney and, from a prosecutor perspective. But the committee members are listed here on this slide. Much thanks to them. I've shared the priorities of the committee previously, but we do have a couple of the priorities that are reflected in this ordinance are reducing the proliferation of cannabis products in our schools and among our youth, and allowing for local business development for producers and retailers of cannabis products. The law went into effect in 2023, and there were some modifications in 2024. It creates a tax structure and does commit to sharing 20% of tax revenue from gross receipts of cannabis retail sales with local governments. It creates the Office of Cannabis Management, which will be the exclusive authority to license any cannabis-related business. It also, as you, Madam Chair, mentioned, put the expungements into effect. It rescheduled marijuana from Schedule 1 to Schedule 3, which is a reduction in the restrictions on use of marijuana. We're going to talk about cannabis plants, cannabis flower, cannabis concentrate, and cannabis products. Cannabis flower is what the public has been familiar with for a long time. It's the plant that can be consumed by smoking it or by cooking it into a product. Cannabis concentrate is by its nature going to be a stronger, more potent version. It's going to have a higher psychoactive effect because it's going to have a higher percentage of THC, because these are coming from the resins that are extracted from the flower or plant. And then cannabis products is just a phrase that means any product made with the extraction or with cannabis concentration or the cannabis plant that contains cannabis. I also want to mention lower potency hemp edibles, which you also mentioned, Madam Chair. So because these are derived from hemp, they wound up on the shelf a lot earlier than the cannabis products will wind up on the shelf, because hemp was deregulated federally earlier and it can be, you can also extract THC, tetrahydrocannabinols, and CBD from hemp at a lower potency and create these products. We don't regulate these except for, in our proposed ordinance, with the exception of a little bit of restriction on advertising and placement of those products. So I'll talk about that in this presentation. But primarily, we're going to be talking about cannabis businesses that are selling that higher potency plant and plant concentrates. Okay, so here are the types of cannabis businesses that the OCM is going to license. There's a lot of different businesses, and they each have their own definition. Those businesses that we're most concerned with from a county perspective, because we're enabled to regulate only these types of businesses, are the cannabis retailers. So those are the stores that buy their products from a wholesaler and put them on the shelf for sale. And then the micro business and meso businesses. These businesses can both produce the product, and if they have the retailer endorsement, they can sell it off their shelves also. So the counties and local governments, including cities, are able to regulate the time, place, and manner of micro business and meso business if they have the retail endorsement, and then cannabis retailers. The law made it permissible to possess cannabis if you're over the age of 21. I think it's actually 21 and over. You can possess up to 2 pounds at your residence, up to 2 ounces of cannabis flower in public, up to 8 grams of the concentrate, and up to 800 milligrams of the THC-infused edibles in public. It legalized cannabis paraphernalia, so the sheriff's office can no longer seize that or issue a ticket for it. It legalized giving away cannabis to somebody else who's over 21. And it legalized cultivation of the plants at home, which you've already described, so I won't go into that. Well, a couple details about that. If you're going to cultivate at home, you have to not just stay under the 8 plants or no more than 4 mature, but you also have to have a permanent resident of that residence, has to be 21 or over. That's an additional thing that wasn't mentioned before. And then as far as using cannabis, obviously also you have to be over 21. You can do so in a private residence, including your yard. You can do it on somebody else's private property as long as they have not explicitly prohibited you from doing so. And you can consume cannabis on the premises of an establishment or at an event that has been licensed for on-site consumption by the state of Minnesota. Prohibited possession, obviously not if you're under 21. Whether you're 21 or not, you can't possess at a public or charter school or any school used or owned vehicle or building. You cannot possess at a state correctional facility. This is just an illustration of some of those amounts that we were discussing of the flower. So on the bottom image on the left is 1 ounce of marijuana or 28 grams. You can possess twice that amount in public if you're 21 and over without breaking the law. Prohibited use. So our committee did not come to the county with a recommendation for prohibiting public use of cannabis, in part because there are some restrictions around use that already exist in the state law, also in part because the city of Grand Marais has prohibited in what's probably the busiest part of the county on the most consistent basis. But again, it's up to the commissioners whether you do wish to include this in the statute. So here's what the state does not allow. You can't smoke or vape cannabis in a location where a minor could inhale it. There's no smoking or vaping anywhere where it's prohibited to smoke cigarettes under the Indoor Clean Air Act. So that covers a lot. Not in a public place, not at a public meeting, not in a place of employment, not on public transportation. You can't use at school or in school property or in correctional facilities. We did discuss and dismiss the idea of prohibiting the non-smokable form of cannabis in public places because that's not covered by the Clean Indoor Air Act. And the reason we dismissed it was because of how problematic that would be to enforce. Those products are small, they can easily be hidden, they can easily be consumed if you're under suspicion, and then once it's consumed, how do we prove what was in it in the first place? So we left that out of the ordinance. Can't operate a motor vehicle while you're impaired by these substances, but also not the driver and none of the passengers can use cannabis while in a motor vehicle. That includes smoking it and consuming the edibles or the beverages, even if they're those lower potency type. Let's see, there's no giving cannabis to somebody under the age of 21, and businesses aren't allowed to use cannabis as a promotional gift. So the state has said local governments cannot prohibit any possession, use, or transport of cannabis where the state law has said it's allowed. And the state has said local governments can't prohibit the establishment of a cannabis business that's licensed under state law. However, what we can do is regulate the time, place, and manner of cannabis retail businesses. So we can talk about when it's allowed, where it's allowed, and how they may sell their products. We can require a county registration, accompany that state license before operation in our county, and we can limit the number of registrations that our county issues. We can limit hours of operation as long as we allow at least from 10 a.m. to 9 p.m. We can create buffer zones around retail cannabis operations that keep them away from schools, daycares, playgrounds, and athletic fields. I've already talked about we can prohibit public use. We can adopt regulations related to cannabis events. We can enact more stringent measures regarding secondhand smoke or involuntary exposure to the vaping. There's an asterisk on requiring a county registration because now if the city of Grand Marais were to wish to pass its own ordinance requiring city registration of these cannabis retailers, the city gets to determine itself how many registrations are allowed within the city, or they can determine that they don't wish to limit it at all, in which case they can disregard the county's limit. So that's why there's a limit on that. Okay. The ordinance itself. So the main thing that our ordinance does is it does require a county registration for any cannabis retailer business. Again, those are cannabis retailers, and those are micro and meso businesses with the retailer endorsement. There's a $500 registration fee, which is the maximum allowed under statute. There's a $1,000 renewal fee. The county is allowed to charge for registration, but not for the application. So if somebody applies and is turned down, we don't get to charge them. The things we need is we need in that application to know the address and parcel ID for the business. We need them to certify they're compliant with all local ordinances, so they have to have their septic in line, and all their signage needs to be consistent with the county signage ordinance, or in the case of a city retail business, with the city's signage ordinance. They need to certify, or any property where one of these businesses is proposed to go needs to be up to date in property taxes. And then we did add a requirement that the business have adequate commercial liability insurance and be able to prove that with their application. When a local government takes on registration, the local government also under the statute takes on the responsibility for doing annual compliance checks. So, and the state law specifically makes some requirements of what those should look like. They have to include kind of a sting operation for age compliance, and we can also check for operational compliance. So some of the requirements that are required by the state are like a security plan for the space, proper labeling of the products. Those are the kind of things that could be checked for compliance. And I should just take a breath here and invite either committee member who is here, if you guys want to interrupt and add or ask questions or correct me, please do.
No, I think you're right on track.
Okay. And then the ordinance enables us to suspend that registration for violation of any ordinance, including this ordinance or any other county ordinance, violation of state law or federal law, which in effect will make the business not be able to operate in Cook County if we need to suspend them. We also enable the county auditor to issue a civil penalty for violation of the registration requirement. The other major part of registration in the proposed ordinance is that we're limiting the number of registrations that can be issued in the county, thereby limiting the number of cannabis retail businesses that can operate in the county. We limit them to 14, and I can explain how we got there. And we also say we can have just 2 in each of these specific areas, and we lay out 7 different areas. Those areas are the city of Grand Marais, each of the organized townships, of which there are 3 on the west end, Lutzen, Tofty, and Schroeder. And then there are 3 unorganized territories that are defined by township and range as the Gunflint area, the Lutzen area, and the Hovland Grand Portage area. So under the proposed ordinance, each of these can have 2 cannabis retailer registrations issued. The reason we set it up like this is because we were modeling this registration requirement with the off-sale liquor store license structure that we have in our alcohol ordinance, which defines these same geographic regions and says you can have 1 store per each of these. We chose 2 in recognition that there are kind of 2 types of cannabis retailers that are contemplated under the licensing scheme. There's the type that sells only the wholesale products that they get elsewhere, and then there's the type that both makes the product and sells it. So, and comparing this to something that happens in the Grand Marais, for example, there's a liquor store which gets its products wholesale and sells them off the shelf. And then you have Voyageur Brewing, which makes its beer on-site and sells it retail. So we were contemplating that there should be the opportunity for at least 1 of each of those businesses in each of these geographic areas. That said, we do not reserve 1 of each type. So really it depends on who's getting the license and asking for the registration. It might be 2 straight retailers. It could be 2 micro businesses. But we just wanted to provide that opportunity. And again, these are recommendations that are coming to you, and commissioners have the authority to change them, change the limit. We did institute the buffers that the state law enables us to institute. So 500, every cannabis retailer business must be outside of 500 feet of a school, daycare, residential treatment facility, or an attraction within a public park that is regularly used by minors and includes a playground or athletic field. We're trying, go ahead, Chris.
This isn't just for retail businesses on this one. This is for all cannabis businesses, I believe. Because we could create the buffer zones for cultivators and manufacturers as well. This is one of the few where we could regulate where they can operate.
That's
I
right.
believe.
That's right. Thank you. So while we can't limit the number of those other types of licenses, we can put buffer zones around. We do have that zoning authority, which is a little more broad. Thanks for pointing that out. Okay, and then in sections 3.2 and 3.2.2, we're just talking about, here are the zones where these registrations can go. So it's a little more specific than the geographic zones. These are commercial enterprises, so under our current zoning ordinance, whether we had the cannabis ordinance or not, these businesses need to be in commercial zones, or they need to be in zones which would allow them as a conditional use permit or interim use permit. So those zones are specifically listed in the statute. We do recommend, through the ordinance, limiting the hours of operation of cannabis retail businesses between the hours of 10 a.m. and 10 p.m. This is roughly modeled after your typical liquor store hours. Without a limit on hours of operation in this ordinance, these businesses could operate between 8 a.m. and 2 a.m. the next day. Related to advertising, so we have a couple different advertising sections in the proposed cannabis regulation ordinance. The first is related to the cannabis businesses. And this is simply taking the language from the state statute and putting it straight into our county ordinance, because this requirement exists already in state statute, that cannabis businesses are permitted to erect up to 2 fixed signs on the exterior of the building or property of the business. No more than that. And then we have a reference to the Cook County's sign ordinance. It says, unless otherwise limited by Cook County's sign ordinance. Then we got a little bit into the weeds of advertising and marketing of and placement of the lower potency edible and beverage products. So under the state law, lower potency edibles already have restrictions as to where they need to be in the store. They have to be stored in a locked case or behind a checkout counter. We added a requirement via this proposed ordinance that they also be at least 1 foot separated from conventional candy and gum products that kids could consume and buy. And then the state statute does not appear to regulate where the beverages, the lower potency hemp beverages, are placed in the store. We added a little bit of that. We tried to be reasonable, understanding that this is gonna be some expense to business owners, but wanting to make sure that we got those, that they were not so easily in the hands of kids. So the lower potency hemp beverages have to be stored in a location or using a method which provides increased theft prevention compared to the non-hemp derived products. For example, top shelved, continuously surveilled, and or locked. And they have to be in a location that's labeled clearly as containing products only for purchase or consumption by persons 21 and over. So that's to try to avoid confusion between the products that a kid can have and the products that a kid can't have. And then with low potency hemp derived beverages and edibles in this ordinance that we're recommending, we're requiring that any advertising inside the store be above 3 feet. And that's just intended to be out of the view of small children so that they're not passively accessing the marketing for THC and hemp-derived beverages. And then we gave the low-potency hemp products the same outdoor advertising restriction that is in the statute for the cannabis products, so up to 2 fixed signs. Let's see. And then just to clarify, within the city, the sign ordinance will apply, and outside of the city, the county's sign ordinance will also apply. So these are not the only restrictions on signage that the business owner is going to have to keep track of.
Can I add one thing? Part of the placement of the low dose or low potency edibles was that it was the realization of the committee that we are unable to, a lot of businesses are unable to create cooler space behind counters that are already in place. Because a lot of stores have limited space behind their counter, so to add a large cooler behind there would disallow a lot of businesses from being able to sell beverages. So the idea being that putting them under constant surveillance would help to limit like having it behind the counter would. So.
Do you want to just describe what you have in your store? 'Cause it's similar, right?
In my store, so Clearview General Store, we have a cooler that is in a separate area of our store. It's in a little cubby towards the back of the store. And that cooler has 3-2 beer currently and beverages. And that's all that's in that cooler. It is at least 10 or 15 feet away from the rest of our cooler space. And there are no other products immediately near that. And there is a camera directed at that space. So it's visible from the front counter constantly. And there's a sign on it that says 21 and over on that cooler. So.
Thank you. Any questions so far? I'm almost through this. I am going faster than last time. Prohibited acts by underage persons. So in the state statute, there is no criminal penalty for a person under 18 who possesses the cannabis or transports it or uses it. So what we are saying, it is a petty misdemeanor for a child, well, anyone under the age of 21, but honestly for 18, 19, and 20-year-olds, we have a state statute that we could charge them under, so it's likely we would be using this only for the juveniles. To possess, transport, or use 2 ounces or less of cannabis flower, 8 grams or less of cannabis concentrate, or the edible cannabis products, lower potency hemp edibles, or hemp-derived consumer products. So a member of the public asked a good question at 1 o'clock, which is, why are you limiting this to 2 ounces or less? Shouldn't it be any amount? And the reason the statute looks like, or the ordinance looks like this, is because there are penalties for 2 ounces or more. I need to make a note to change this language, because I think it should say under 2 ounces of cannabis flower.
Because there are pieces in the statute for anybody possessing
right.
more than that. So adults or under 21, it doesn't matter, it would apply to all.
Yeah. What's missing is the penalty for juveniles to possess any amount under 2 ounces. So that's what we're trying to do here. We're not, the first couple times the juvenile is caught violating this provision, they're going to get the same penalty that an adult would, which is a petty misdemeanor. Essentially a fine if you're an adult, and if you're a kid, it could be you get a probation officer, you get community service, or you have to do some kind of an evaluation. But the third time you get caught as a juvenile, you can be charged with a misdemeanor offense. That is going to, as long as other circumstances are present, is going to allow the court, if needed, to order the child into residential treatment. That's considered out-of-home placement. As I've mentioned in another meeting, there are other considerations that a court has to make before they order a child into out-of-home placement. It has to be the least restrictive setting for the child, so there has to be a determination that this is it. This is really the only option to rehabilitate this child and get them the help they need. And I want to point out that Children are rarely ordered into out-of-home placement as a result of a delinquency. Typically, there are other things going on. But adding the misdemeanor here could be a tool for those cases where there really isn't a better option for the kid other than a limited time in a residential treatment place. We also make it a petty misdemeanor for any person to use a form of false ID to purchase or attempt to purchase cannabis, or to use somebody else's ID. And same rule for this. The first 2 times is a petty misdemeanor, the third would be a misdemeanor. And it's actually any combination of violations of Section 6. So if you violate by using twice and you use a false ID a third time, you can have the misdemeanor charge the third time. And finally, Section 7 of the proposed ordinance does enable the city and the county to each open their own municipal cannabis retail business. So this is an enabling ordinance. It does not mean that there is a plan in place on either the county or the city's part to do so. Obviously, that would be an investment of resources, employees, likely a new department, a location, all of those things. But it does enable either local government to move forward in that sort of project in the future if they wish, without amending the ordinance or passing a new ordinance. That's all I've got. I'm just going to put our opportunities for public feedback up on the screen so that people can see those. And I do also want to offer, Madam Chair, that there are some comments that have come in on our website, which I could read aloud if you're interested in hearing them. Otherwise, I'm just going to accumulate them in a packet and file them with the ordinance when we file the board packet for next week.
Yeah, I imagine there'll be a number coming in over the next few days, so thank you for doing that. I think the packet is appropriate.
Okay.
Any questions for Attorney Hicken at this time? Any remarks from others that were on the committee? Okay. So at this point, we'd like to open it up for an opportunity for public comment. Are there any individuals who would like to make comment this afternoon? Any individuals who would like to make comment?
I have a question as an individual and commissioner.
Mm-hmm.
What is a cannabis event?
Oh,
So part of the reason we didn't include that in our proposed ordinance is we're not sure yet.
Well, they actually, so.
Oh, did they
there's
recently
there's
publish?
language.
So recently, on the 31st, OCM published their first draft for cannabis rules. It's an 111-page document that details the rules for every license category as well as general rules. The cannabis event would be a lot like imagine a vendor show that you could go to. So you would have possibly retailers or other cannabis businesses that would display product or not to liken it to something that's family friendly, but kind of like the vendor show at Fish Pick, where you have booths and things like that that people can go to. You can apply for a permit that would allow, or the license that would allow you to have retailers that could then sell. Those retailers would need their own license and their own retailer license from a fixed brick and mortar space. You can also have paraphernalia or other merchandise available. But there are a lot of restrictions with it. You can also do on-site consumption. But with that, you would need a fenced-in area. You'd need to limit access by minors. You would need to limit sight by minors to that space. And the same large-scale security pieces that apply to all retail businesses would also apply to that event. And so it could be held at any space as long as they apply for the license. But we would need a part of that in our ordinance as well. So yeah, it could be a number of different things. It can go for up to 4 days. And there are a lot more rules as part of that packet. And this is just the first draft that they've come out with. But does that help?
Yes, thank you.
Yeah.
And there will be a lot of information and questions answered this Friday. The Association of Minnesota Counties is putting on a webinar from 10 to 11. And there'll be many, many people attending, a lot of commissioners attending from throughout the state. And MCIT, who is our insurer, is putting on a presentation at the end of August in St. Cloud, and that's going to be very well attended. So there's lots of information to come, but I just appreciate the work the committee has done to get this in place and to review this. We are far ahead of other counties. We've worked ahead, we've been proactive rather than just waiting and waiting, and so I want to thank all of you for the really good work that you've done.
Commissioner Sullivan? And also the question was about, Lake County has a moratorium, and I think that should be explained that that's not the way to go. Attorney Hicken?
I can talk a little bit about moratoriums. I know that this is something that the board did discuss maybe a year ago. The thing about a moratorium is that a local government is enabled to issue a moratorium. In other words, to say there's going to be no sales of cannabis here for this period of time. They can only do that if they're going to come out at the end of that moratorium with a study and say, we've studied the issue and these are our recommendations on how to regulate it. And under the cannabis statute, it does enable local governments to issue a moratorium, but you cannot prohibit use through that moratorium, so we're not shutting that down. You can only prohibit sales. Sales aren't happening here anyway until 2025. And then the moratorium must expire at the end of this year, December 31st. So, back a year ago, this board discussed it and kind of dismissed that as an option. So I haven't been working on it, and I don't have a proposed moratorium for you. If we were to put one in place now, I would question why we're doing it, because we have had this committee meeting since May, exploring the issue, discussing it, gathering data, kind of doing a study, and I don't know that we're going to be in any different of a place at the end of this year by putting the moratorium in place. The other thing is, say we did put a moratorium in place and we didn't take action on this proposed ordinance, so we didn't set up the requirement for registration, we didn't limit the number of registrations in the county, and that moratorium stayed in place until December 31st. Beginning January 1st, 2025, when our moratorium has expired, the state can start issuing licenses, and potentially the state could issue more licenses in this county than we're comfortable having. So it has been a long time since I considered the moratorium. It just came up again at our town hall last night. But those are my current feelings about it.
And I asked for public information so people would understand, because it sounds like a good idea, but then the state could say, well, we're ready to go, and as you said, it might be contrary to what we want for this county.
It seems like the work of the committee has provided us with potential guardrails, a structure to work with, and the piece I like is that it's a 2-year committee, that we're going to collect data, we're going to look at information on, the number of driving offenses, how many kids have been suspended from school or had, some kind of issue in the community, but we're going to collect data and look at it so that then we can tweak this and make it better to make sure that we're not only providing business opportunities, but we're protecting our youth and being reasonable in our community. And I think the group has done a great job of getting this started, so thank you. Well, there are no public comments out there to be made today for our hearing. So with that, I'd just like to remind people they can continue to give feedback on our website, where you can submit a written comment. You can call 218-264-1094 and leave a comment via voicemail. And next Monday, we also have an opportunity for people to come to the ACA, the Arrowhead Center for the Arts, and participate in a town hall. And with that, I would like to thank you all very much for your attendance. It's really important we had this today. This was publicly noticed in the Cook County News Herald, our legal newspaper, and so it's important to have this hearing and make sure that even if the room isn't filled with people, that we've recorded this and made it available for our community. So thank you so much. We are adjourned.
Thank you.
Thank you. Your Honor. That's what I want to call you, Your Honor.
Having any
I stumble over, Madam Chair.